Here in Arizona, there's no such thing as a free bite. If a dog bites you, the owner is responsible, even if that dog has never bitten someone before, even if it's never so much as growled at the mailman, even if the owner did everything right, leash, fence, training, all of it. That rule is called strict liability, and Arizona has one of the strongest versions of it in the country. And in the next few minutes, I'm going to explain to you who is responsible for a dog bite, what those damages are, what the defenses are, and a few things to be aware of. Because most of us have a dog in the home or interact with it, so it's important to know what our responsibilities and rights are. And to give you some real-life examples, meet Rosie. Rosie is our family Tibetan Terrier. She joined our family in 2017 and is the sweetest dog you could ever meet. But if she bites somebody, I'm going to be responsible for it. And so I'm going to give you some examples of what would happen. But first, let's start with the law itself. The owner of a dog that bites a person is liable for the damages if that person was in a public place or lawfully in a private place. And lawfully in a private place includes being a guest in the dog owner's home or backyard. Now notice what the statute doesn't say. It says nothing about the dog owner knowing it was dangerous. It says nothing about the dog owner being careless. That's exactly what strict liability means. In a normal injury case, I have to prove that the other person was negligent or unreasonable. But in a dog bite case, that doesn't apply. The only things that I have to prove are that my client was bitten, that the owner of the dog is actually the owner, and that my client was in a lawful place. A lot of states handle this very differently, and something called the one bite rule applies. The victim has to prove that the dog was dangerous, that it had bitten someone before. And if the victim cannot prove that, then unfortunately they're out of luck. Arizona rejects that rule. Here is the national picture. 23 states have a broad, strict liability statute like ours. If the dog bites, the owner pays. 12 states are still one bite or pure negligence states. No dog bite statute at all, so that the victim has to prove that the owner knew the dog was dangerous or was careless with it. And 15 states sit somewhere in the middle, with statutes that only go part way. Some only cover medical bills, some only cover serious injuries, some only apply when the dog is running loose. Add it up, and every state with any kind of strict liability statute on the books is 38 to 12. The takeaway from this map, in most of the country, and especially here in Arizona, you keep the dog, you answer for the dog. So who is considered the owner? Surprisingly, in Arizona, it's much broader than you would think. And this is the question that surprises many of my clients. It's not just the person whose name is on the adoption papers or on a vet bill. Arizona statute section 11-1001 defines who an owner is. It says that an owner includes anyone keeping a dog for more than 6 consecutive days. And our courts have told us what keeping means. In the case of Spearlong versus Brown, the Arizona Court of Appeals held that keeping a dog means exercising care, custody, or control over the dog, feeding it, walking it, taking it as your responsibility for more than 6 consecutive days. It's about controlling the dog, not just owning the roof that's over the dog's head. So let's make that real for you. Your sister leaves her dog at your home for the next 2 weeks, and you're feeding it, walking it, taking care of it every day. Under Arizona law, you're the dog's owner. And if that dog bites somebody on day 9, you're going to be responsible for those damages, not just your sister. On the flip side, in the Spearlong versus Brown case that the Court of Appeals determined, the homeowner had allowed a roommate to move in who had a dog. The roommate did all of the caring for the dog, feeding it, cleaning up after it, walking it, and the homeowner did nothing. The Court of Appeals held that although the dog had been in the home for more than 6 days, the homeowner was not the owner of the dog because it had not exercised custody, control, or care over that dog while it had been in the home. Now, if you own a dog and you're watching this, probably wondering, is there any defense to this? And there's exactly one: provocation. Under A.R.S. 11-1027, if the person who got bitten provoked the dog, it's a defense to a strict liability claim, and the only defense. And it's measured by a reasonable person standard. The question is whether a reasonable person would expect that the conduct would provoke a dog. Pulling a dog's tail, hitting it, stepping on it, cornering it, messing with its food or with its puppies. A jury can find that that is provocation and that the owner is not responsible for the damages from a bite. But walking past a dog, reaching out to let it sniff your hand, or a toddler wobbling and falling on the dog, that is not provocation. And that's the list of defenses. The dog owner doesn't have to know that it was dangerous. It doesn't have a claim of, I had no idea that my dog would do this. Provocation is the only defense. So my sweet Rosie that I've shown you here has never had any type of bad interaction with anyone. However, if she were to bite any guest of mine in our home or while we're out in public, I'm going to be responsible for making sure that the injured party is taken care of. So that raises the question of who is paying for those damages. Here's the question I hear in almost every one of these cases. Usually because the dog belongs to a neighbor, a friend, or a family member, I don't want to take their house or go after the person individually. So who's actually paying for this? And the answer, in almost every case, is insurance. Dog bite claims are covered by homeowners' insurance policies or renters' insurance under the personal liability portion of that policy. That's the same coverage that protects them if someone slipped and fell on their property. And that liability coverage is for the person, not just the address. So if the bite happens outside of the home, at the park, in a public place, or wherever, the owner's policy still covers them for liability. When we bring a dog bite claim, we're dealing with an insurance company and the coverage that the owner has been paying premiums for all along, not their savings account. One caveat: some policies exclude certain breeds, and that's a specific situation that comes up every once in a while that we have to read the policy language to see if there is an exclusion. But the majority of the cases will fall under this liability provision of their homeowners or renters insurance. Now, one important thing I have to let you know before you go, a strict liability claim, like we've been talking about, carries a shorter deadline than most injury cases. 1 year from the date of the bite versus 2 years for an ordinary negligence claim. So if you're involved in a car accident, you generally have 2 years to make a claim, but for a dog bite or strict liability claim in Arizona, you only have 1 year. So don't sit on it. If you or your child have been bitten by a dog here in Arizona, contact us. The consultation is free. And if this video helped you understand your rights and your responsibilities as a dog owner, do me a favor and subscribe as we post more videos that describe your rights and responsibilities under Arizona law. Thanks for watching. I'll see you on the next one.